Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in United States v. Miller. In this case, the court considered this issue. May a bankruptcy trustee avoid a debtor's tax payment to the United States under 11 U.S.C. Section 544B when no actual creditor could have obtained relief under the applicable state fraudulent transfer law outside of bankruptcy? The case was decided on March 26, 2025. The Supreme Court held that Section 106A of the Bankruptcy Code abrogates sovereign immunity for the federal cause of action created by Section 544B, but it does not take the additional step of abrogating sovereign immunity for whatever state law claim supplies the applicable law for a trustee's Section 544B claim. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Jackson delivered the opinion of the court. The Bankruptcy Code empowers a bankruptcy trustee to set aside, or avoid, certain transfers of a debtor's assets in order to recover those assets for the benefit of the bankruptcy estate. This case concerns the trustee's avoidance powers under Section 544B of the Code. Under that provision, a trustee may avoid certain transfers that would be voidable under applicable law, that is, voidable outside of bankruptcy proceedings. Trustees typically rely on state statutes to supply the applicable law when suing under Section 544B to avoid a debtor's transfer of assets. In this dispute, a trustee invoked Utah law as the basis for a Section 544B suit seeking to claw back a debtor's federal tax payment. Ordinarily, the federal government's sovereign immunity would bar any suit against it under Utah law. But the Bankruptcy Code contains a sovereign immunity waiver, Section 106A, that abrogates the government's sovereign immunity with respect to Section 544. This case requires us to determine the scope of that waiver. Specifically, we must decide whether Section 106A abrogates sovereign immunity only with respect to the federal cause of action created by Section 544B, or whether it also abrogates sovereign immunity with respect to the underlying state law claims that supply the applicable law for that federal cause of action. We hold that Section 106A's sovereign immunity waiver applies only to the Section 544B claim itself and not to any state law claims nested within that federal claim. Section 106A is properly understood as a jurisdictional provision that empowers courts to hear Section 544B claims against the government to the extent such claims are otherwise available under state law. It does not alter the substantive meaning of Section 544B's applicable law clause. We therefore reverse the decision below. Bankruptcy trustees have long had the power to invalidate, or avoid, certain transfers of assets made by a debtor. These avoidance powers serve multiple ends. Most obviously, they help the trustee maximize the value of the bankruptcy estate by enabling the trustee to recover assets that otherwise would have been lost. The avoidance powers also help the trustee equalize the distribution of the debtor's assets among creditors by preventing the debtor from offloading assets to preferred creditors outside of the formal bankruptcy process. Today, the avoidance powers are codified in Chapter 5 of the Bankruptcy Code, which delineates the specific types of transfers that trustees are empowered to set aside. Section 545 of the Code, for instance, permits a trustee to avoid the transfer of certain statutory liens. Meanwhile, Section 547B allows a trustee to invalidate transfers that the debtor made immediately before bankruptcy proceedings began. And Section 548 permits a trustee to set aside certain fraudulent transfers, such as those made for the purpose of delaying or impeding the repayment of creditors. This case involves the trustee's avoidance powers under Section 544B. That provision allows a trustee to avoid any transfer of an interest of the debtor that is voidable under applicable law by a creditor holding an unsecured claim. Although the term applicable law can technically refer to any state or federal law outside of the Bankruptcy Code, trustees typically rely on state statutes to supply the applicable law for avoidance suits under Section 544B. The state statutes that trustees most often invoke are known as fraudulent transfer laws. These laws, which generally employ the same language from state to state, aim to prevent debtors from hiding or shielding their assets from creditors. To that end, most fraudulent transfer statutes provide creditors with a cause of action to invalidate any transfer that a debtor made with the intent to defraud creditors. Creditors may also typically invoke these laws to void constructive fraudulent transfers, that is, transfers made without an actual intent to defraud, such as an insolvent debtor's sale or transfer of assets for something less than their equivalent value. Notably, to show that a transfer is voidable under applicable law, a bankruptcy trustee must identify the actual creditor or creditors who could have set aside the transaction in question under applicable law. If there is no creditor against whom the transfer is voidable under the applicable law, the trustee is powerless to act. This actual creditor requirement serves as an important check on the trustee's Section 544B powers. Absent the actual creditor requirement, a trustee could use Section 544B to unwind transactions that would never actually be at risk of invalidation outside of bankruptcy proceedings. The actual creditor requirement thus mitigates the disruptive potential of a trustee's avoidance power by ensuring that the trustee has no greater rights of avoidance than the actual creditor would have if that creditor were asserting invalidity on its own behalf. This case arises from the collapse of a Utah-based transportation business called All Resort Group. The company fell into insolvency in 2013 as the result of poor management and financial malfeasance. As the company struggled financially, two of its shareholders began misappropriating company funds for their own personal use, including to pay off personal debts. In 2014, they transferred roughly $145,000 in company funds to the Internal Revenue Service to satisfy their personal income tax obligations. The company received nothing in return for paying off these shareholders' debts. 3 years later, the company filed for bankruptcy. Respondent was appointed as trustee of the bankruptcy estate. He filed this suit against the United States under Section 544B shortly after his appointment, seeking to avoid the 2014 tax payments. Respondent invoked Utah's fraudulent transfer statute as the source of applicable law for his Section 544B claim. Like most fraudulent transfer laws, Utah's statute allows a creditor to void a debtor's transfer of assets if the debtor was insolvent at the time of the transfer and received less than equal value in return. The parties cross-moved for summary judgment in bankruptcy court. The government did not contest respondent's allegation that All Resort Group was insolvent when it made the 2014 tax payments on behalf of its shareholders. Nor did it dispute that the company received nothing of value in exchange for making those payments. Instead, the government asserted that respondent's claim failed because he could not satisfy Section 544B's actual creditor requirement. Specifically, the government argued, respondent could not identify any creditor capable of prevailing in a fraudulent transfer suit against the government under Utah law because, outside of bankruptcy, any such suit would be barred by sovereign immunity. The bankruptcy court rejected that argument and entered judgment for respondent. The court based its decision on Section 106A of the Bankruptcy Code, which waives the government's sovereign immunity for certain claims arising under the code. In particular, Section 106A(1) provides that sovereign immunity is abrogated as to a governmental unit to the extent set forth in this section with respect to 59 different provisions of the code, including Section 544. The bankruptcy court construed Section 106A as waiving the government's sovereign immunity not only as to the trustee's Section 544B claim, but also as to the underlying state law cause of action nested within the Section 544B claim. Accordingly, the court held that sovereign immunity does not preclude respondent from satisfying the actual creditor requirement. The district court adopted the bankruptcy court's decision and the 10th Circuit later affirmed. Like the bankruptcy court, the 10th Circuit concluded that Section 106A expresses Congress's intent to abolish the government's sovereign immunity in an avoidance proceeding arising under Section 544B(1), regardless of the context in which the defense arises. The 10th Circuit's decision reinforced a conflict among the courts of appeals regarding whether Section 106A abrogates sovereign immunity with respect to a state law claim that supplies the applicable law for a trustee's Section 544B claim. We granted certiorari to resolve that conflict. This dispute turns on the interplay between Section 106A and Section 544B of the Bankruptcy Code. The parties here agree that Section 106A waives the government's sovereign immunity with respect to the federal cause of action created by Section 544B. But respondent contends that Section 106A goes further than that by also waiving sovereign immunity with respect to whatever state law cause of action a trustee might invoke as the source of applicable law for his or her Section 544B claim. As explained below, we hold that Section 106A does not sweep as broadly as respondent maintains. Waivers of sovereign immunity are jurisdictional provisions that empower courts to hear claims against the government but do not themselves typically create any new substantive rights against the government. Here, statutory text, context, and structure all demonstrate that Section 106A fits squarely within that mold. For that reason, we conclude that Section 106A does not alter the substantive meaning of Section 544B's applicable law clause by providing a waiver of immunity that would not otherwise exist under that external source of law. Before discussing Section 106A itself, it is helpful to recall how waivers of sovereign immunity operate in general. As our precedents explain, sovereign immunity is jurisdictional in nature and deprives courts of the power to hear suits against the United States absent Congress's express consent. In providing that consent, waivers of sovereign immunity function simply as prerequisites for jurisdiction. They do not create any new substantive rights or alter any pre-existing ones. That is precisely the role that Section 106A plays within the Bankruptcy Code. Section 106A(1) provides that the federal government's sovereign immunity is abrogated with respect to several dozen provisions of the Code, thereby granting courts the power to hear claims against the government under those provisions. That includes the power to hear claims under Section 544, which is among the listed provisions. At the same time, Section 106A(5) expressly provides that nothing in this section shall create any substantive claim for relief or cause of action not otherwise existing under this title, the Federal Rules of Bankruptcy Procedure, or non-bankruptcy law. In this way, Section 106A's text, read as a whole, makes clear that it operates like any other waiver of sovereign immunity. It is merely jurisdictional and does not establish any substantive rights against the government. Respondents' reading of Section 106A departs from that conventional understanding of sovereign immunity waivers. Under respondents' view, Section 106A does not simply give courts jurisdiction to hear Section 544B claims against the government. It also alters the substantive requirements of the claim itself. It is undisputed that, outside of bankruptcy proceedings, the United States could invoke the defense of sovereign immunity to bar any lawsuit seeking to invalidate a federal tax payment under a state's fraudulent transfer law. That barrier to state law liability would ordinarily doom a trustee's Section 544B claim by making it impossible for the trustee to show that the tax payment at issue is voidable under applicable law by an actual creditor. But, respondent contends, Section 106A vitiates that barrier by abrogating the government's sovereign immunity with respect to both the Section 544B claim and the state law claim nested within it. As respondent puts it, Section 106A's clear waiver with respect to Section 544 applies equally to the trustee's Section 544B cause of action and the applicable law that provides the elements of that cause of action. Respondents' reading of Section 106A would thus transform that statute from a jurisdiction-creating provision into a liability-creating provision. But we have declined to read sovereign immunity waivers in that way. Rather, we have said that the question whether there has been a waiver of sovereign immunity is analytically distinct from the question whether the source of substantive law upon which the claimant relies provides an avenue for relief. Respondent conflates these two questions by seeking to leverage Section 106A's waiver of immunity, i.e., the statute's grant of jurisdiction, into an affirmative expansion of the trustee's avoidance powers under Section 544B. Construing Section 106A to modify the elements of a Section 544B claim would thus reflect a highly unusual understanding of sovereign immunity waivers. That alone casts doubt on respondents' reading of Section 106A. But even if that reading did not conflict with our normal understanding of sovereign immunity waivers, it would remain untenable as a basic matter of text and structure. The text and structure of Section 106 and Section 544 make clear that Section 106A's waiver of sovereign immunity does not operate to modify Section 544B's substantive requirements. As noted above, Section 106A expressly states that it does not create any substantive claim for relief or cause of action not otherwise existing under some other source of law. That language plainly refutes the notion that Section 106A's sovereign immunity waiver extends to both the cause of action that Section 544B establishes and its elements. Indeed, construing Section 106A to modify the elements of a Section 544B claim would necessarily give the trustee a substantive claim for relief against the government that does not otherwise exist under Section 544B or Utah law. Section 106A's text thus confirms that it does not alter Section 544B's substantive requirements. So, too, does the list of Bankruptcy Code provisions identified in Section 106A itself. Notably, Section 106A does not meaningfully alter the substantive obligations of trustees under any of the 58 other provisions that appear on the list alongside Section 544. So far as we are aware, the other avoidance provisions on the list retain the same substantive elements regardless of whether the trustee is suing the government or a private entity. Given that Section 106A leaves the substantive elements of those avoidance provisions untouched, it would be odd to read the provision as modifying the elements of Section 544B. Section 544's own text and structure reinforce that conclusion. Recall that Section 544B requires a trustee to identify an actual creditor capable of voiding the transfer at issue under applicable law. That actual creditor requirement, which restricts the universe of transactions a trustee can invalidate, is unique to Section 544B. Section 544's only other subprovision, subsection A, conspicuously eschews any such requirement. Instead, subsection A permits a trustee to invalidate certain transfers that could have been voided by a lien creditor, whether or not such a creditor exists. That contrast in structure reflects a deliberate congressional choice to tie the trustee's rights under subsection B to the rights of an actual creditor under applicable law. We doubt that Congress meant to supplant that choice when it opted to include Section 544 on the lengthy list of provisions it inserted into Section 106A. What is more, eliminating the actual creditor requirement would upend decades of practice and precedent. Section 544B was expressly derived from Section 70E of the Bankruptcy Act of 1898, which had long been understood to give trustees the same rights as creditors under state law. As one widely cited lower court decision put it, Section 70E clothed the trustee with no new or additional right over that possessed by a creditor. It merely placed the trustee in the shoes of the creditor, subject to the same limitations and disabilities that would have beset the creditor in the prosecution of the action on his own behalf. Section 544B carried forward that same understanding of the trustee's role. That is why, for example, defendants in Section 544B suits are entitled to raise the same defenses against the trustee that they would have been able to raise against the relevant creditor under applicable state law. Thus, if the creditor is deemed estopped to recover upon a claim, or is barred from recovery because of the running of a statute of limitations prior to the commencement of the case, the trustee is likewise estopped or barred. Similarly, if the applicable state law allows a prevailing party to recover attorney's fees, then a defendant who wins a Section 544B suit can typically recover such fees from the bankruptcy estate. This long-settled understanding of the trustee's Section 544B powers, and their limits, underscores why it would be so anomalous to treat Section 106A as expanding the trustee's rights beyond those of an actual creditor. Even if the language and logic of Section 544 and Section 106A permitted respondents' broad reading of the sovereign immunity waiver, we note further that our precedents would still foreclose that reading. Under long-settled law, Congress must use unmistakable language to abrogate sovereign immunity. That means that we must construe any ambiguities in the scope of a waiver in favor of the sovereign. Here, Section 106A's language unmistakably waives sovereign immunity for the federal cause of action created by Section 544B. But for all of the reasons just given, we cannot say that it does the same for the state law claims nested within Section 544B's applicable law clause. Respondent interprets Section 106A differently. He asserts that Section 106A, 1's use of the phrase with respect to requires a broad reading of the statute's sovereign immunity waiver, citing dictionary definitions and cases that adopt capacious readings of similar phrases. These sources, he says, evince Congress's intent to abrogate sovereign immunity for all subjects that concern or regard the listed provisions, including the meaning of applicable law in Section 544B. The authorities respondent invokes, however, cannot bear the weight he foists upon them. Even setting aside that many of his authorities concern different statutory terms, they all examine those terms in very different statutory contexts. For instance, he cites our observation that the use of the word respecting in a legal context generally has a broadening effect. But the statute at issue used the term respecting in a quite dissimilar setting, as part of the technical phrase statements respecting the debtor's or an insider's financial condition. Giving breadth to a discrete statutory term like financial condition is a far cry from expanding a sovereign immunity waiver, especially when our general rule is that waivers of sovereign immunity are to be read narrowly. Respondent's textual argument thus flouts a fundamental canon of statutory construction, that the words of a statute must be read in their context and with a view to their place in the overall statutory scheme. That canon carries particular force when construing phrases that govern conceptual relationships, like with respect to whose meanings inherently depend on their surrounding context. Here, context cuts decidedly against the broad reading respondent advances. As explained, construing Section 106A to reach the elements of Section 544B would not only run counter to our traditional understanding of sovereign immunity waivers as purely jurisdictional, but also contravene the text and structure of Section 106A and Section 544B, and defy our established rule that sovereign immunity waivers must be construed narrowly. Section 106A's use of a malleable phrase like with respect to cannot blunt the countervailing force of those contextual considerations and interpretive principles. Cf. Rejecting a broad reading of the phrase with respect to voting in the Voting Rights Act where doing so would work an unconstrained expansion of its coverage. Respondent resists the force of those contextual considerations by appealing to Section 106A's enactment history. He emphasizes that Congress purposefully expanded the scope of Section 106A's immunity waiver in 1994 by adding the list of 59 specific provisions, including Section 544, to the statute. But no amount of legislative history can supply a waiver that is not clearly evident from the language of the statute. And, even if legislative history could serve that function, respondents' account of Section 106A's history is incomplete at best. Since its adoption in 1978, Section 106 has always been understood to provide only a limited waiver of sovereign immunity in bankruptcy cases. The House and Senate reports accompanying the 1978 legislation both expressly stated, Though Congress has the power to waive sovereign immunity for the federal government completely in bankruptcy cases, the policy followed here is designed to achieve approximately the same result that would prevail outside of bankruptcy. This suggests that, at the time of enactment, Congress understood the statute to preserve a basic symmetry between bankruptcy and non-bankruptcy proceedings, not to expand transferee liability within the bankruptcy system. Nothing in the 1994 amendments to Section 106 dislodged that original understanding. When Congress adopted Section 106A's current language in 1994, it did so with the narrow aim of overturning two of this court's decisions. Those decisions, neither of which involve Section 544B itself, had held that Section 106's immunity waiver did not reach monetary judgments entered against the government. The 1994 amendments served to clarify that Section 106 does, in fact, expressly provide for a waiver of sovereign immunity with respect to monetary recoveries. But the amendments did not expand Section 106's scope beyond what Congress envisioned in 1978. Rather, their goal was to make Section 106 conform to the congressional intent of the Bankruptcy Reform Act of 1978. In sum, Section 106A's enactment history, to the extent it plays any role here, undercuts respondents' broad reading of Section 106A and reaffirms what the statute's text makes evident, that in waiving sovereign immunity with respect to Section 544, Congress did not alter the substantive elements of Section 544 itself. Respondent gained slightly more traction in arguing that the government's reading of Section 106A would blunt the impact of Congress's decision to include Section 544 on the list of provisions subject to Section 106A's immunity waiver. After all, respondent says, if sovereign immunity bars every state law claim capable of furnishing the applicable law for a Section 544B suit, then, as a practical matter, no trustee could ever win such a suit against the government. Thus, respondent asserts, the government's reading of Section 106A effectively robs the immunity waiver of any meaningful purpose with respect to Section 544. It simply grants federal courts jurisdiction over a set of inherently unwinnable claims. We are not persuaded that the government's reading extinguishes Section 106A's effect with respect to Section 544. For one thing, even if Section 106A does not enable trustees to prevail against the government under Section 544B, they might still prevail against the government under Section 544's other subprovision, subsection A. As noted above, subsection A, unlike subsection B, does not contain an actual creditor requirement. A trustee can therefore use subsection A to set aside certain transfers, specifically, transfers of certain liens, without identifying an actual creditor capable of invalidating those transfers under state law. And federal tax law separately provides that tax liens held by the federal government may be invalidated under particular circumstances. As a result, a trustee can avoid transfers of certain tax liens under Section 544A without identifying an actual creditor, and without needing to identify a waiver of immunity to sustain a claim under the Internal Revenue Code. By giving courts jurisdiction to hear those types of claims against the government, then, Section 106A serves a clear purpose with respect to Section 544. Respondent rejects that understanding of Section 106A, insisting that the waiver must be construed to give substantive effect to all of Section 544's subsections, not just subsection A. He stresses that Section 106A, 1's list of provisions refers to Section 544 as a whole, without demarcating any specific subsections. But the same is true of the 58 other Bankruptcy Code provisions on the list, many of which include subsections that plainly do not implicate sovereign immunity at all. Section 303, for example, appears on the list even though subsection A of that provision authorizes a kind of action, involuntary bankruptcy petitions, that cannot be filed against the government. The list also includes Section 106 itself, despite the obvious incongruity of applying Section 106A to its own waiver of sovereign immunity. The sheer number of provisions on the list with subsections that cannot plausibly be the subject of an immunity waiver rebuts respondents' strained reading of Section 106A. It is also noteworthy that, in addition to the role that Section 106A plays with respect to Section 544A, the waiver provision serves an independent function with respect to Section 544B. It grants federal courts jurisdiction to hear Section 544B claims brought against state governments. As outlined earlier, Section 106A abrogates sovereign immunity not just for the federal government, but for any governmental unit, which includes any state. At the time Congress enacted Section 106A, a handful of states had chosen to subject themselves to potential liability under their own fraudulent transfer statutes. Section 106A thus granted federal courts jurisdiction to hear Section 544B suits against those states, jurisdiction that those courts would have otherwise lacked. Respondent's argument also lacks support in our precedent. Respondent cites our recent decision as evidence that Congress sometimes waives sovereign immunity while simultaneously establishing a new substantive right against the government. But the statutory provision at issue bears little resemblance, in text, structure, or operation, to Section 106A. We held that a provision of the Fair Credit Reporting Act that explicitly permitted consumer claims for damages against the government also functioned as a waiver of sovereign immunity for those claims. Our decision rested on the straightforward proposition that a cause of action authorizing suit against the government may waive sovereign immunity even without a separate waiver provision. That proposition is hardly controversial. If Congress establishes a cause of action that, by its own explicit terms, authorizes suits against the government, then Congress need not also enact an independent waiver of sovereign immunity. That logic, however, has no bearing on the question at issue here, namely, whether Congress waived sovereign immunity for a state cause of action that does not explicitly authorize suits against the government. Nothing suggests that courts should presume, in the absence of explicit language to the contrary, that Congress has waived the federal government's sovereign immunity for such claims. If anything, counsels in the opposite direction. Our opinion there reaffirmed that a waiver of sovereign immunity must be unmistakably clear in the language of the statute. And, once again, for all of the reasons previously discussed, Section 106A does not contain an unmistakably clear waiver of immunity for state law claims nested within Section 544B's applicable law clause. Finally, we decline respondent's invitation to affirm on other grounds. As an alternative basis for ruling in his favor, respondent proposes a novel reading of Section 544B that would purportedly allow a trustee to set aside a federal tax payment without ever triggering the federal government's sovereign immunity. Per that reading, the trustee could satisfy the actual creditor requirement by showing that applicable state law would permit a creditor to void the tax payment by suing someone other than the United States. Respondent claims that he can do that here because Utah law would, in theory, permit an all-resort group creditor to void the 2014 tax payments by suing the two shareholders who orchestrated those payments, neither of whom is protected by sovereign immunity. We will not address this argument because it turns on readings of both Utah law and Section 544B that no other court has ever considered. Furthermore, respondent failed to raise this argument below. Additionally, the question this argument poses has not been adequately briefed and argued here. We therefore leave it to the courts below to decide whether respondent may pursue this argument on remand. Section 106A of the Bankruptcy Code abrogates sovereign immunity for the federal cause of action created by Section 544B. It does not take the additional step of abrogating sovereign immunity for whatever state law claim supplies the applicable law for a trustee's Section 544B claim. Accordingly, the decision of the 10th Circuit is reversed. It is so ordered. Justice Gorsuch, dissenting. The court has often warned against confusing the doctrine of sovereign immunity with the requirement that a plaintiff state a cause of action. Yet, to my eyes, the court's decision today suffers a like confusion. Three statutory provisions are relevant here. First is 11 U.S.C. Section 106A, 1, which waives the government's sovereign immunity with respect to Section 544 of the Bankruptcy Code. Second is Section 544B, 1, which empowers a bankruptcy trustee to invoke the rights of a creditor holding an unsecured claim to set aside any transfer that is voidable under applicable law. And third is Utah's fraudulent-transfer statute, which here supplies the applicable law for purposes of Section 544B, 1. Utah Code Section 25-62031, 2025. As I see it, those three provisions play out this way. Under the Utah statute, a transfer is voidable if, after a creditor's claim arose against the debtor, 1. Made the transfer, 2. Without receiving a reasonably equivalent value in exchange, and 3. Was insolvent at the time. Notably, no one before us disputes that these conditions are satisfied here and a good fraudulent transfer claim exists. Thus, under applicable law, the relevant transfers are voidable, and the bankruptcy trustee can use Section 544B, 1, to set them aside. That remains true even though the trustee must sue the United States to void the relevant transfers, because Section 106A, 1, bars the government from raising a sovereign immunity defense in the trustee's action. The court worries that my line of thinking would modify the elements of a Section 544B claim. More exactly, the court observes that, if a creditor sued the government directly under Utah's fraudulent transfer statute, the government could interpose a successful sovereign immunity defense, and the creditor would lose. And, the court fears, reading Section 106A, 1, to allow a bankruptcy trustee to bring the same claim under Section 544B, 1, would impermissibly give the trustee a substantive claim for relief against the government that does not otherwise exist. Quoting Section 106A, 5, alterations omitted, expressing concern that my reading would alter a core substantive requirement of the underlying Section 544B claim. It seems to me, however, that the court conflates two different things. Whether pursued by a private creditor or a bankruptcy trustee, a good substantive claim for relief exists. No one disputes that a fraudulent transfer took place. The question before us is a distinct one. Can the federal government defeat the claim by raising the affirmative defense of sovereign immunity? With respect to a private creditor pursuing relief in state court, the answer is yes. With respect to a trustee pursuing relief in a federal bankruptcy proceeding, the answer, thanks to Section 106A, 1 is no. Admitting that much does not modify the elements of any claim or create any substantive claim for relief that did not otherwise exist. It merely acknowledges that in one setting, but not another, Congress has chosen to waive an affirmative defense to an otherwise valid claim. For these reasons, I agree with the majority of circuits to have considered the question that bankruptcy trustees may avoid fraudulent transfers to the United States under Section 544B. As the court concludes otherwise, I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.